Good evening. This is Laws 12067 Environmental Law. It's Week 3, Term 3, 2015. And this week, the topic is environmental law and the common law. We're finishing off some detail in relation to Week 2, which relates to environmental law in a legal context. So before I get on to environmental protection and the common law is Week 3. So before I get on to that, I just want to finish off with a few comments in relation to last week's material in relation to the issue of environmental law in legal context. Chapter 2 of Bates' texts has a lot of material that relates to the acquisition of land or the restriction of rights, and has some commentary in relation to when and if compensation is payable. And the basic rule is that if there is an acquisition of property, then that is compensable under the Constitution. But if it's merely a restriction in relation to a right or perhaps a privilege, then generally that is not compensable. In looking at Moodle, I see that one student, Patrick Fitzgerald, provided an excellent response to the first question, which deals with the overall structure of the separation of powers. And I won't go through this in too much depth, but he did make reference to the Van Son decision quite rightly. And the point of that particular case is that the executive are not in a position where they can introduce through licensing systems what is effectively a deprivation of a common law right, and the court upheld the landowner's entitlements in that case. He also correctly makes reference to the Yorta Yorta Aboriginal Community against Victoria case. That's referred to in Bates, and I'd recommend that you have a look at that in terms of the context of determining what is relevant regarding the separation of powers in environmental law. Just on that, it's very basic really, in a sense that we have the legislature, we have the executive, we have the judiciary, and in our system, theoretically, they're all separate. We know that they're not. We know that members of parliament, so a minister, for example, has a foot in two camps. So we tolerate, if you like, those differences, but we try to maintain that separation. And that has an importance in the context of the acquisition of rights, as we've seen by that discussion on the Van Son case. And I appreciate I'm moving fairly quickly, but I take it you've read the material, and if you have any questions, please raise that as we go or through UCRU during the week. Do have a look at the decision in Environmental Protection and Rashley and contrast that, see where that approach has been confirmed by the High Court in ICM Agriculture against the Commonwealth. That's 2009. And Liz, thank you for, I think it was you, Liz, raising an issue in relation to water aquifers and the cancellation of bore licences. That gave me cause to consider the case of Arnold, the High Court decision in 2010. If you haven't read it, have a look at that. There's some commentary in UCRU, and that talks about the High Court holding that the cancellation of licences and the issue of aquifer licences did not constitute an acquisition of property within the constitutional section 51 subsection 31. Now, I know that's very quick, so it was really just meant to give you an idea of what I think might be important in the context of this area of law. If there are any questions, please stop me and let me know. All right, so common law, it is referred to in chapter 2 of the text, and at 220, Bates makes the comment that the courts often see themselves as providing essential protection to the rights of the individual against overzealous use of government powers. I mean, that quote goes straight to the issue of separation of powers. It raises the question of the ability of the courts to intervene in certain circumstances, as it were, to come to the protection of the landowner, and also to deal with that issue of compensation. But what it doesn't do in the context of environmental law is provide any form of basis for the common law to come to the protection of the environment generally, because it just doesn't. It's not built for that. And so in that sense, the common law is not a champion of environmental law at first instance. And the champion, if I can use that term, and that's just my term, of the environmental law has to be through legislation. And once that's drafted, once that's implemented, we can see that legislation can take effect. Now, why do I say that it's the Parliament that has to be the champion in this regard? Well, common law, courts don't recognise environmental law as a basis for any form of relief. And the executive, as we've seen through that Von Son case, does not have the power to effectively intervene unless it has the power conferred upon it by legislation. So all of this has to commence through legislation. And if we go back to week 1, we can see that the legislation, in many ways, particularly at Commonwealth level, is reflective of the obligations imposed upon the government or the Parliament by the government ratifying international treaties. So just tying that up, going back into weeks 1 and weeks 2. All right, are there any questions about that? I won't bore you anymore. Yes, Tony?
Why can't they have a referendum to put the environmental issues in the Constitution?
They could.
You know, because,
yeah.
My thinking is that, 100 years ago, it was the last thing on anyone's mind, right? And, because it's got a big following nowadays, and, it's my opinion that I think everyone wants to leave the environment in the same condition, if not better, for the generations to come and that. And if you did have a referendum on it, it'd probably get up if the right questions were asked.
Yes, not too many referendum issues are successful, typically, historically, but no, there's no reason why that can't be done. That could be changed in the Constitution, but at the moment it's workable through the bilateral agreements between the Commonwealth and the states, and all of that came into existence, and indeed the EPBCA came into existence because the states effectively allowed the Commonwealth that ability to do so. So in the 80s, there were a lot of constitutional challenges about the way in which the Commonwealth was intervening in what was perceived to be state issues. The Tasmanian Dam case would be the leading example of that.
Yeah.
Now, Shane says the Republicans argue the language of the Republic referendum in 2000 was key to defeating the referendum. Exactly. And I think that's a fair point. And I think that's what you were saying, Tony. The language would have to be right for that to be successful.
Yeah, but just going off on a tangent with this Republican issue, at the time that was put, Howard wasn't he didn't want a republic, but the majority of Australians did. But he put forward the question, like if he had to put forward a question, do you want a republic, yes or no, and we'll work out what model, after, it would have got up. But people didn't want the republic model that he was putting forward. That's why it failed.
No, I think that's a fair comment. Liz, do you have Liz has a question?
Yes, thank you, John. I own up, I have not read chapter 2 yet, so I might be asking a question that
you're right
answered in the book. But when it comes to it not being covered by common law, is it still covered by common law, say, for example, where it's a government department that has done destruction of the environment? Would that become common law because it's an abuse of power, or you look to another area of law depending on what has happened, and then it becomes common law, a common law area, because they've got it legislated where they can prosecute, but there's very little there for an opportunity for an ordinary person to have the same opportunity as what they do, because they've got all the big money they can keep on prosecuting to the highest court and, it doesn't affect them. But when it comes to the ordinary person, challenging events that have occurred where there's damage being done to the environment, is there a crossover of some way that it's not covered in legislation, but it's still able to be a common law area?
No, that's an excellent question. Thank you very much. So when I say the common law can't champion environmental law, I am in a sense talking historically. And if I could answer your question sort of in a lengthy form, but I'll try to be efficient with doing so. If we think about the position, say, in the 60s, environmental movement hadn't commenced. There were clearly environmental issues that needed to be considered. There were two issues facing potential litigants that sought redress through the common law, and that was firstly they had no standing, and the second is there was no nice, neat common law principle that could assist. So let me be a bit more specific. Prior to the introduction of legislation that would come to the aid of someone wanting to champion a cause to do with the environment, the first issue was standing. What that means is that you could go in and say, look, this wrong is happening to the environment, and I would like an order to stop it, an injunction. At common law, you'd have to prove that you had standing, and standing is that ability to say, I have the right to be here to argue this case. And typically, at common law, the courts would say, you don't have a special interest over and above anyone in the community, therefore we're not giving you standing. So standing at common law meant that you had to establish that you had a special interest or you were directly affected. So that was the first issue. The second issue was that there's just not that nice, neat, tortious or contractual claim that you could make. So if, for example, an industry was polluting a river, and I'm talking pre-legislation days, as a concerned member of the public, if you were able to overcome that standing issue, which was considerable, and actually, as it were, get your foot in the door to argue the toss in relation to what was happening to the environment, at common law, they would say, but you've suffered no damage. And I know that you could say collectively we've all suffered damage as a result of the harm to the environment, but common law tortious principles would allow you to sue under nuisance or negligence or things of that nature, but you would have to show that you were the one affected by it. So in a sense, standing came into it again. So that's why I say common law didn't help in terms of championing the environment. Now, to go forward in responding to your question, once the legislation is enacted, typically it will bind the Crown. So if you want to know whether or not you have a right to challenge in a court, which is common law, actions which are being taken by a government which may harm the environment, the first thing is to overcome the standing laws. It's much easier now than it was many years ago. And in New South Wales, there is no prohibition. Everyone has standing under the state laws there. But it's much easier, generally speaking. But the second thing is that you can say that the particular legislation requires enforcement, and in the Queensland context, if you wanted to obtain an enforcement order, you'd probably look at Section 601 of the Sustainable Planning Act, which provides for a court to make enforcement orders at the complaint of any person. And then you look at the particular action that's being complained against you look at the legislation, and typically the legislation will say that it binds the Crown. So you rely on Section 601, seek an enforcement order. You do that by originating application, and you argue that the particular government in question has breached an environmental law, and that particular environmental law prescribes that the Crown is bound by it. So I'm sorry, Liz, that's a very long answer to your question. I hope that's an adequate answer.
Yeah, no, thank you, John. That answered a lot, and
Okay.
hence I can see where the gaps are where I haven't read chapter 2, but that 601
Yes.
is really interesting, and then I can sort of have a look at different areas in different states as well.
Yes.
But at least got that basis to start with. Thank you very much.
No, that's right. And of course, I apologise for those of you interstate, as it were, that most of the state material is Queensland-based, although I do try to introduce a material from New South Wales and Victoria and other jurisdictions from time to time if I can. Now, looking ahead, what you'll see is that the Planning and Environment Court has jurisdiction to make declaratory and injunctive orders. That's under section 479, I recall, of the Planning and Environment Court, or the enforcement order, section 601, that I mentioned before. Or it could be that in a particular application to the court, you claim both declaratory relief and, say, an enforcement order. I think I mentioned the Byrne Brothers case last week. That was an instance where an application was made under section 601 of the SPA seeking an enforcement order. So that's an example. And if you read the case law in the Planning and Environment Court jurisdiction, you can categorise them in two ways. The first way is that, and this is most of them, they're mostly merits appeals, which is where it's an administrative action, and a merits appeal is where the court is asked to step into the shoes of the decision maker and make a decision which is ostensibly executive in nature or administrative in nature. So it's not a judicial review, it's a merits review. So that's what most of them are. And it might be, for example, and in real terms, those merits reviews come to the court in circumstances where a developer is dissatisfied with a rejection of an application, a development application, or is dissatisfied with the conditions that have been imposed in that development application. And that particular application might relate to a development which is what we call impact assessable, or it might be concurrence issues, or it might be a compliance assessment. So different types of developments could become the subject of a merits review at the behest of an applicant developer, or alternatively, a concerned citizen or a submitter, if you like, or an objector can issue an application in the court for a merits review in relation to a decision made about what we call an impact assessable development, so a particular type of development. So the point I'm trying to make, and I'm using a lot of words to say it, is that when you're reading the Planning and Environment Court decisions, most of them will be merits reviews, but some of them will be cases that relate to the seeking of declaratory or enforcement orders or injunction orders, and they're quite separate, really. Did you follow me on that? Okay, but don't worry, there'll be more in the notes. We'll have a lot of notes that come through, and hopefully that will better explain it. So if your head is spinning a bit with all those terms, then don't worry, we'll go over that again in more detail and more thoroughly. Okay, no other questions at the moment, but thank you very much for those questions, Tony and Liz. If you have any other questions, or anyone else, please come on in. I'd just like you to consider the question. Yes, Shane. Shane has a question.
Yeah, sorry, I just have a question about the compulsory acquisition of land. I can't remember off my head, but from doing property law, for compensation, is that just for the Commonwealth compulsory acquisition of land, or does that include a state doing acquisition of land as well? Because I thought I read somewhere, I'm thinking off my head here, that it didn't apply for states, that it hadn't been decided.
Yeah, look, under the Constitution, Section 51(31), which relates to the acquisition of land, only relates to the Commonwealth. However, the states do provide compensation in circumstances where there is a compulsory acquisition. Now, certainly it happens, but as for the basis upon which that happens, I'm not sure. Sorry to be a bit vague on the answer. So if, for example, an institution requires a resumption for road widening, main roads, there will be compensation payable. Tony, do you have anything to add to that?
Yeah, I work for Powell in Queensland High Voltage Transmission Line Company 15 years, and they do, like, you can negotiate easements or compulsory acquire them. And what they do, the states, and like it's a state government-owned corporation, and they do pay compensation. And what usually happens is the constructing authority will say to the landholder, like, you go out and talk to the landholder, and you'll say, we're going to acquire this land for this transmission line because people want electricity or water transmission lines, whatever. And they'll say, they usually say, well, we're going to get a valuation done of the easement we're going to acquire on the property. And what we want you to do, we'll pay for you to go and get your own valuation. The landholder's valuer will value high because he's going to do the best thing for that the client. The constructing authority, their valuer will value low because they want to get the best deal for them. So you've got a price here and a value here. You sit down, and somewhere in the middle is the price that you'll negotiate to be what you're paying compensation. And up until I think it was about 2010, there was no sunset clause on paying compensation. You could claim the compensation 20 years later, 30 years later. But they brought this sunset clause in that said you've got 3 years to claim the compensation, right? And people were up in arms about that. However, we got advice from, when I was working at Powell, they got advice when this came in I think it's the Acquisition Land Act. They got advice from Clayton Utes, and the experts there said, the sunset clause of 3 years is only there to get people to claim the compensation so it doesn't hang around and these constructing authorities can close their projects off and that. Because until you've paid the compensation, you can't close capital projects and that off. So, and they said, well, basically, if 3 years is up, there's not a court in the country that wouldn't let you get compensation for the easement on your property because of the just terms thing. They can't just come in and take it. So, yeah.
Thanks, Tony.
No, that's right.
Yeah, thanks, Tony.
Okay. All right. So thanks very much for that, Shane. Just have a look at the question of delegated legislation. It's an interesting one because there's a crossover between Parliament and the Executive. I may have included a quote in the material from John Carvin. It's in a text called Understanding the Australian Legal System. And in that text at page 39, Mr. Carvin makes the comment that society now is very complex, much more complex than it was many years ago. And as a result of that, Parliament delegates certain powers to others to come up with the detail to flesh out the overall legislation. So there's some rationale behind the idea of delegated legislation in that regard. And the delegated legislation does enable others to take some control over that process, but it must only be in circumstances where there is a specific conferring of power. And it's used sparingly, of course, because it potentially does offend the separation of powers doctrine. But just do some reading on delegated legislation, if you would, at some stage. All right. Now, I would like to just go through the notes from the material that we provided, the notes that I wrote for this subject. And can I just say that the notes are all written, but I'm going through the process of proofreading, and I think I've released weeks up to 5. 6 and 8 are just about ready to go. 7's being checked again, and I'm working on 9 and 10 in detail at the moment. But in Chapter 3, Environmental Protection and the Common Law, we talk about the position of the common law, the need for statutory intervention, along the lines of what I've mentioned before, and that is that the common law really didn't come to champion the cause of environmental interests. But when you're reading the material, in terms of the issue of compensation, you need to bear in mind the division between that which is owned or is property compared to a permissive right, such as a lease or an easement, covenant or profit or prondra, and they may not be compensable in circumstances where the permissive right is lost, as opposed to the compensation that must be paid on the just terms provisions of the Constitution where there is an acquisition of property. So it's always that difficult issue. Bear in mind, of course, that politically, in many instances, the state governments may argue that the Commonwealth should fund statutory schemes which provide for structural adjustments in circumstances where there is maybe not a loss of property per se, but a loss of an ability to use land in the way that people would like them to do. And that was seen in Queensland with the introduction of the amendments to the Vegetation Management Act a couple of years ago, where the state government of Queensland sought Commonwealth funding to assist in its structural adjustments compensation scheme. So it may be very commercially important if you're advising a client in terms of whether they have property which might be compensable if it's lost through a different licensing regime, as opposed to a permissive right or a license which will not be compensable. Now, it's not related to environmental law, of course, but we're seeing this at the moment with the introduction of the Uber and the competition on taxi licenses, taxi licensees now saying, well, these licenses aren't worth as much, so we want to be compensated the loss. And the argument is that, well, you've already done that in the past for other industries such as fishing, so why shouldn't we receive compensation when, through the introduction of competition or alternate licensing regimes, or lack of them, as the case may be, that their circumstance has changed. So the nature of the interest is really the important thing there. Now, legislation, of course, overrules the common law, and that's why legislation in the environmental context is so important and so powerful, because it can simply overrule what was done before. However, there is the issue of to what extent and when can legislation prevail over private contracts or covenants, and there's some commentary in the text material that I've written. I referred to Adrian Bradbrook's publication. Many of you doing land law may have seen that. And the issue there is that town planning considerations will be held irrelevant at common law in establishing whether grounds exist for modification or discharge of a restrictive covenant. There's the case example that I've raised there is Hume Cole against Alexander from 2013, and that related to a conflict between the provisions of the Mining Act and entitlements conferred by private covenant. And in that instance, the court did provide for injunctive relief to prevent the parties from restraining contrary to the terms of the legislation, albeit that it was consistent with the private covenants. So in that instance, it's a good example of where the courts will uphold what's in the legislation, even though it may not be consistent with the restrictive covenants that were in place. Section 181 of the Property Law Act in Queensland deals with the issue and provides the Supreme Court with actual power to modify or extinguish easements or restrictive covenants in certain circumstances. So the lesson there is that you may believe that you have an entitlement which is absolute, but it can be overcome as a result of an application through the Supreme Court and an order made. Common law actions, I talk about their negligence, and the negligence claim, of course, only relates in circumstances where the person claiming has been directly affected by the act of negligence, as going back to a point that we referred to earlier. And then finally in the chapter I talk about the statutory schemes as a means of displacing common law liability, and those statutory schemes that I've talked about are generally structural adjustment schemes. Talk about SLAP suits and equitable remedies. All right, so if there are any questions about what's in the textbook, please let me know. Otherwise, I'll move on. Okay. It might be appropriate then to consider the weekly problems, the tutorial problems. Thank you for those people that have provided a response. I've already made reference to Patrick's answer to question number 1, which was last week. So don't worry if you haven't got round to answering questions 2 or 3, which are this week's questions or problems, then don't worry, it's not too late to do so. So problem 2 relates to the question of whether the common law has any role to play in the development of environmental policy and environmental law. I've suggested that it didn't have the ability to be the champion, but it still very much has a role to play. First of all, we go back to that issue of separation of powers. Of course, common law has a role to play because, as Liz pointed out through her question before, we need to have somewhere that we can go to make complaint. And if we don't have that, then we've got a dictatorship. So there's clearly that issue, and the role of the common law, the courts can provide or insist upon transparency and accountability, and that can be done through judicial review, which, although statutory based now, is really a common law principle. Common law can also provide a way of translating environmental policy, common law rights can be overcome through environmental law policy, and that is done through legislation. But it must be subject to that rider of the Commonwealth Constitution, that the acquisition of property must be on just terms. All right. Problem 3 relates to public bodies taking steps to establish through legislation ways of protecting the environment. Okay. How does the common law fit into that? Does it mean that the common law has no part to play in environmental management? So, as we've said, the common law doesn't recognise environmental degradation as actionable per se, but it's still relevant. Common law, I suppose, does support the ownership of property. It's the backbone of our capitalist democracy, I guess, in many ways. But common law still provides remedies that relate to environmental damage through actions such as nuisance and negligence. Common law can provide remedies through damages or an injunction, considering the equitable relief that might be available there. So if you are a party that is directly affected, the common law can assist in dealing with environmental damage. But generally speaking, there are those issues that we talked about before of standing and not being directly affected that might get in the way. Statutory entitlements are probably built on a common law base. So there's a lot of discussions in the material that you've read in cases where people argue about an ability to draw water, for example, or to fish or extract minerals and forests minerals and forest products. So all of that relates to common law principles in terms of the rights of a landowner or the rights of a person holding a permissive interest, such as a profit a pronda. So the common law still has a role to play there. And of course, given that environmental law is now essentially legislative based, we still need the courts, the common law, to recognise and interpret, or to rather interpret the legislation. And in doing that, the courts will go back and deal with it based on common law principles and concepts. And the common law, of course, is required to provide a means of enforcing, as we've talked about, through enforcement orders or through injunctions or declarations. And of course, common law issues to do with legal costs still comes into play as well. Now, there were two answers that I saw on the Moodle site, one from Cassie, one from Jessica, both really good. Cassie's answer goes into issues to do with the fact that common law is still reflective of the fundamental nature of our society, and that common law rules still relate to the operation of statutory schemes. Makes reference to Bates and says, if concepts understood at common law are not altered in any way by a statute, then Parliament must intend that the statute should be interpreted in accordance with the principles of common law. So it's important to remember that default position, that the common law will provide that basis for interpreting legislation unless there is a specific statement to the contrary. So that's a very good answer. Jessica offers some comments in relation to legislation drafting or being drafted to overcome known and prospective issues, and goes into talking about scientific research, community discussions, and that's excellent. And then makes reference to an example of a contractor ceasing work on a site when there is found to be a migratory stopover for species of birds. So she concludes quite rightly that common law will continue to play a role at this time and probably for time to come. So thank you very much for those excellent contributions. Are there any questions in relation to problem 2 or problem 3 in the material? Any comments in relation to what I've said or what Jessica or Cassie have said? All right. Well, that's probably all that I wanted to cover tonight. So a relatively short session tonight. Just looking ahead, there'll be some pretty lengthy materials provided to you. I don't think I've yet produced weeks 6 and 9, I think from memory, are very lengthy. But work your way through them. They're important issues. We've got some guest speakers coming up. On the 10th of January, Andrew McGoffin, who is one of your students, one of our students in this course, is a town planning consultant, and he has very kindly volunteered to assist us in considering the IDAS process, which is referred to in the Sustainable Planning Act, and that will be excellent. On the 17th of December, we have Sean Ryan, who's a principal solicitor from the Queensland Environmental Defenders Office, and he'll be talking to us about issues to do with community litigants and the difficulties that people face. And Tony, I'm sure, will have plenty of questions for Andrew McGoffin by the look of it from his chat line comments. So beware, Andrew. And then next year, Phil Jeston is going to provide us with his insights. Phil is an environmental scientist, and he will be talking specifically about environmental impact statement, environmental impact assessment. And where I'm interested in what Phil has to say is that it's important that we understand from the scientific perspective what is relevant and what goes into those assessment processes. Phil has already provided some commentary. You'll see that on Zoom. So have a look at that, because what he wants to do is work from that base and supplement. So you'll need to go back and have a look at that material. Okay, well, thank you very much for your patience and your attentiveness tonight. Before I stop, so I think Liz has some questions. Thank you, Liz.
Yeah, sorry, John. I was just referring to the scientific part of looking forward to that discussion in regards to asking them questions about how they develop the best practice principle for environmental law.
No, that will be good. Thank you for that comment. And of course, it's interesting as a lawyer coming into environmental law, because we're familiar with two basic tests. That is, on the balance of probability, 50-50, 51-50, 49. That's the civil standard. And we're familiar with the criminal standard, which is beyond all reasonable doubt. But the scientific standard is, that sort of 95% threshold. So it's a different standard again. And then, of course, we have the precautionary principle, where we really don't have to prove anything definitively at all for action to take place. And if you haven't got to the precautionary principle, that's one of the elements of ecologically sustainable development. You'll read about that. The precautionary principle sets another test as well, which is not really the criminal test, it's not really the scientific test, it's not really the civil test, it's somewhere in between all of those things as well. So there are a few different ways of looking at things, and there are a few different standards that need to be met before certain aspects are invoked in environmental law. So thank you for your comments there, Liz. All right, are there any questions or comments from anyone else? We're all still, we've got a few people there, that's great. Thank you very much. All right, well, all the best. I'll stop recording, and next week is a holiday week, so we won't be online next week, but we'll see you the week after that. All the best.